Judiciary and Public Safety Committee. And the date today is Wednesday, March 17th, 2021. We have a rather full agenda today, and we're going to start with Civil Legal Service budget presentation for the first 10 minutes. And I will ask Mr. Drew Schaefer, the Executive Director, to make the presentation. And I have lost my screen. Oh, he's bringing something up. Okay. Mr. Schaefer, are you on board with us? I see you. Please identify yourself for the record and then proceed with your testimony. And also for the record, we do have quorum. Mr. Schaefer.
Thank you so much, Chair Limmer. Thank you, Senator Latz, all of you for being here and welcoming Civil Legal Services this afternoon. I am Drew Schaefer. I am the Executive Director of Mid-Minnesota Legal Aid. I am going to attempt to share my screen if that will work for all of you. So let me know if this is working.
It is.
All right. So again, thank you. Drew Schaefer from Mid-Minnesota Legal Aid, representing the Minnesota Legal Services Coalition and Civil Legal Services here this afternoon for a budget presentation. I want to just start out by highlighting who we are and what we do. Civil Legal Services provides statewide critical legal help in civil cases touching all 87 counties in Minnesota. We do this through a network of regional programs that provide broad poverty law services to people with critical civil legal needs, including the elderly, people with disabilities, Black, Indigenous, and people of color, and people that are living in poverty around the state of Minnesota. We also have partners that provide targeted services in specific geographical areas and practice areas to meet the needs of Minnesotans statewide. So that is who we are and what we do. I am going to talk next about why we are here and why we are requesting an increase in funding for civil legal services in fiscal years 2022 and fiscal year 2023. I'm showing you a graphic that depicts what we are experiencing and have been for some time, the civil legal aid compensation deficit crisis. So our attorneys statewide start with an average salary of just over $50,000. Meanwhile, first-year public defenders who are also underpaid start with a first-year salary of $65,800. Judicial branch associate attorneys start at a salary of over $62,000. And you can see that as an attorney at one of our offices providing critical legal services to Minnesotans statewide moves up in experience, the compensation is just not there to allow them to continue to deliver justice to Minnesotans statewide. So, for example, a civil legal services attorney with 7 years of experience has an average salary of just under $57,000. A civil legal services attorney with 10 years of experience has an average salary of just over $60,000. So we are starting over 30% behind where assistant public defenders start. And as a result, we are struggling to keep our staff retained and to continue to provide the services that are so important to people around the state of Minnesota. So this is the crisis that we've been experiencing. We have been left behind gradually over the last decade with this gap growing larger and larger, with attorneys and other colleagues in all roles at all our offices doing all the important things to deliver justice to Minnesotans falling further and further behind, to a point where even one of our talented attorneys who has 10 years of experience being behind first-year starting salaries for other legal public interest and public sector employers. So the current state of affairs for legislative appropriation for civil legal services is an annual funding level of $14.72 million. This appropriation is leveraged by other resources that we develop to fund a total civil legal services system at a current revenue level of just under $46 million. We know that to meet all the needs of Minnesotans statewide in the critical civil legal cases that we prioritize, family safety, keeping people housed, protecting seniors from exploitation and abuse, protecting consumers, providing people access to healthcare, all of those critical services. Right now we struggle. We are forced to turn away over half of the people who come to us for help. We know that to meet all the needs, it would take a total investment of just under $75 million additional dollars on top of the $14.72 million in annual funding that we receive at this time. So that would be to meet all the current needs in all of the critical cases we do in our current legal work priorities. What we are asking for the next biennium is depicted before you right now. We are asking for a $2.208 million increase in fiscal year 2022 and an additional $1.27 million increase in fiscal year 2023. The total biennial budget request is around $5.6 million. And what we are intending to do with this increased funding is to take beginning steps to address the compensation deficit crisis we are experiencing so that we can continue to sustain the current level of services to Minnesotans statewide in the critical cases that we do. And again, I just want to emphasize, right now, we are forced to turn away over half of the Minnesotans who come to us for legal representation help due to lack of resources. And so we're asking for this help so that we can work on addressing the compensation deficit so that we can sustain our current level of service and provide justice to Minnesotans statewide. So that is a high-level summary of the budget request. And with that, I will take questions that anyone on the committee may have. And again, I just want to thank all of you for the important work you do and for welcoming Civil Legal Services to give this presentation today.
Thank you, Ms. Schaefer. We'll open it up for a few questions from our membership. Do we have anyone that wishes to ask Mr. Schaefer any questions? It doesn't look like I am seeing anyone. Let me just go to gallery view. Senator Latz.
Thank you, Mr. Chairman. Not so much a question as it is a comment emphasizing the importance of the legal services that Civil Legal Services provides to people who wouldn't otherwise have legal help. They're in an environment, these individuals are in a whole different world when you get into the legal system. If you don't know what you're doing, you will get lost or trampled. Or you simply will not even attempt to enter, which means that you aren't protecting your rights and others are asserting over you. It's not only these folks vastly underpaid compared to even other public lawyers, let alone what they could be earning in the private sector. They do it because it's really valuable and important to provide these services. But the level of work and the services they provide are just critical to so many people. And these are on issues that are very, very impactful on day-to-day lives of people. So, it's not like, you're fighting a parking ticket or there are some legal processes which, you win, you lose, they're not going to change your life. But for these folks, it does. Which makes it even more critical that they have good representation. So I would really encourage you, Mr. Chairman, as you're looking through your budget, and maybe I'll ask you at some point before the end of the hearing here to give us a little idea of your take on your budget target. But as you're looking through it, I hope you'll find a way to support Civil Legal Services in a great amount.
Thank you.
Thank you.
Thank you, Senator Latz. I wanted to make just tell one brief story that happened in my district. I happen to have an individual. He called every single person he could think of, churches, local city governments. He was being thrown out of a little hotel or a motel in my district. That motel satisfies a number of people that are on welfare payments and living in a hotel room. And he was a former felon, a convict. He was on parole, but nevertheless, he was trying to keep his head above water. And he was being asked to be, by the landlord, he was being evicted. Now, this happened during the governor's executive order. And he didn't know that there was an executive order that prevented that. And I was the only one who called him back. He said, I called 24 people, various public officials, mayors, city council members, churches, pastors, priests, and never even got a return phone call once he told them that of his situation. I called him and I connected him with Civil Legal Service, and they arranged it that that individual could stay in that hotel room for the next 30 days, and that gave him time to kind of get his act together and move on with his life. But if it were not for Civil Legal, that person really would have been lost, as Senator Latz stated. There's just circumstances that are so much bigger for some people, and they just collapse under the weight of it. So, Mr. Schaefer, one quick question. Is the demand for civil legal services going up in the last few years? And I know we have to keep it short because we have a lengthy schedule today. Mr. Schaefer?
Thank you, Chair Limmer. Yes, the demand for civil legal services is increasing. Even in the best of economic times, due to our limited resources, we're forced to turn away people, which breaks our hearts every day when we wake up and are seeking to do justice for Minnesotans. I think that the economic crisis visited upon our client communities over the last year has led to record-setting numbers of calls to our intake lines. We were just looking at the last quarter of statistics for calls to the Minnesota Legal Services Coalition civil legal aid offices and seeing a rate of calls of over 130,000 calls annualized in all of our statewide service area if you just looked at the fourth quarter of 2020. And so, the people of Minnesota need us now more than ever, and to be there for them, we have to be there with our colleagues who are experiencing this compensation deficit crisis. And that's how we can sustain our services and increase our services, is making sure that we value the work that's being done and the justice that we are delivering to people of Minnesota.
Thank you, Mr. Schaefer. Senator Kiffmeyer?
Thank you, Mr. Chair. Mr. Chair, I'm listening to this and the people that they're wanting to serve but don't seem to be able to serve right now. But I'm looking in the budget book right here, and the request is for $5,686,000, and of that, $4,833,000 is to raise the pay, which I understand that. I understand what you're saying, but my concern is the large majority of this is being used for current employees, and what I hear you saying is you'd like to serve more. So that leaves $853,000 left. I'm not sure what else might be expended there, but my concern is in serving more people. And so could you maybe just inform me a little bit more about these resources, and maybe I've misread them, if you can just clarify.
Mr. Schaefer?
Chair Limmer, thank you. Senator Kiffmeyer, thanks for the question. So the way that our budget is structured under the statute, our funds are distributed. 85% of the funds go to the Minnesota Legal Services Coalition civil legal aid providers, and we will be targeting investments towards salary improvement. The rest of the funds are awarded through the judicial branch's Legal Services Advisory Committee in a competitive grant making process. And so those funds are not so much for the general revenue that would support compensation increase, but are for those targeted programs that were on the slide that was followed the title slide of my presentation. And I'm happy to share more information with you about that and to follow up with you, but that's sort of the framework for why the budget request is that way. And we know that to level our playing field on compensation, that it would actually take about $10 million per year more than we are requesting. And to increase services substantially, it would take that type of investment. But mindful of the budget realities we faced entering this session, we believe our request is measured and reasonable and will help support us in advancing towards our goals in the future of serving more Minnesotans and sustaining the services we provide now in the critical areas where we serve them.
Thank you, Mr. Chair. That's all for now. I can follow up.
Thank you. Final comment, Senator Latz?
Thank you, Mr. Chairman. I appreciate Senator Kiffmeyer's focus on that issue, and I'll just use sort of a business analogy. The most important, one of the biggest costs of employers is when they have to manage turnover. They lose employees, have to bring in new employees. It's very expensive to train in new employees, and there's a much lower rate of efficiency in the performance of their job until they get experience in that position. So probably the best thing that the money could be used for from that standpoint would be to make sure you're able to reduce turnover, reduce the number of lawyers who are leaving civil legal services for better pay in a public defender's office or in a county attorney's office or in the private sector. And keep the experienced lawyers who are able to more efficiently process their cases and serve more people in the civil legal services offices. That would be the first step in being able to increase services. Once you're able to have enough pay also to draw in additional attorneys, that's even better. That's really the way to expand. But you'd be working backwards if you're not paying salaries high enough, at least to hang on to the experienced lawyers that you have. And that's a big problem that civil legal services has as well. I think they're the lowest paid among all of the legal services organizations in the state, or certainly close to it if they aren't.
Mr. Chair, I kind of thought that the public
Clerk
defenders were the lowest paid. I'm getting confused by all these. So I appreciate that. I understand that. So sorry, Mr. Chair.
We have to move on.
Yeah.
Thank you, Mr. Schaefer. You've given us a little bit more to chew on. Thank you so much.
Thank you, Chair Limmer, and thanks to all of the members of the committee for hearing from us today.
Yeah, we'll move on to our next order, Guardian Ad Litem Board Budget Presentation by Tammy Baker Olson, Administrator. Ms. Baker Olson.
Good afternoon, Chair Limmer.
Yes, would you identify yourself for the record and then proceed?
Yes, my name is Tammy Baker Olson. Good afternoon, Chair Limmer and committee members. I am the State Program Administrator for the Guardian Ad Litem program. I want to begin my testimony by thanking the legislature. And first, I should probably share my screen, sorry. It knocked them off. Oh my goodness. Oh my goodness.
Hold on one moment. There we go.
Here we are.
We have it up.
Sorry about that.
That's certainly okay, Ms. Baker Olson. Please proceed.
Thank you. I want to begin my testimony by thanking the legislature for its past support, as well as for having me here today to speak on behalf of the Guardian Ad Litem Board. The Guardian Ad Litem Board is a board established in the judicial branch of state government. The board exists so that all children with a court-appointed attorney have their needs met, and that each judicial officer is equipped to make informed decisions for each child within the confines of available resources. The Guardian Ad Litem Board was established in 2010 by Minnesota Statute 480.35. Prior to 2010, the Office of the State Court Administrator established Guardian Ad Litem standards, which were approved by Judicial Council. The State Guardian Ad Litem Board revised the standards and renamed them GAL requirements and guidelines in 2011. The duties and responsibilities of the board are to administer a statewide independent guardian ad litem program. The board consists of 7 appointed members charged with both mandated and permissive duties. Mandated duties require that the board approve and recommend a budget to the legislature, establish procedures for funding distribution, and establish guardian ad litem standards, policies, and procedures. As part of the permissive duties, the board may choose to propose statutory changes. The current board includes 1 retired judge, 1 retired court referee, 4 attorneys, 1 current guardian ad litem, and 1 community member. Guardians ad litem are appointed child advocates who are federally and state mandated on all child protection and family court cases where allegations of abuse and/or neglect are alleged. The responsibility of the guardian ad litem is to advocate for the child's best interests for the duration of the court proceeding, and this is accomplished through 5 core statutorily mandated duties, which are listed on your screen. GAL meet with parents and collaterals associated with a child depending on case specifics. It's often necessary to talk with the child's teacher, therapist, and/or doctors in order to monitor best interests throughout the proceedings. A guardian ad litem is not a neutral, rather an independent voice speaking solely on behalf of children in a system with competing interests. It is important to note a guardian ad litem can only be appointed by a judge. GAL are active in all 87 counties. From January 2019 to January 2020, GAL attended over 33,000 court proceedings and filed over 18,000 court reports. The FY 2021 budget increase provided much needed financial relief that has helped to ensure federal and state compliance and heightened program oversight. The additional funding helped further aid in the development of an independent family court division within the program, as well as help strengthen the program's ICWA initiative. You have before you now the Guardian ad litem Board's FY 22-23 budget request. As you can see in FY 22, the Guardian ad litem Board requests $206,000 in new funding to cover the employer's share of unavoidable healthcare cost increases. However, no increase in compensation. In FY 23, the Guardian ad litem Board requests $444,000 in new funding for a 3% compensation increase and $445,000 to offset employer healthcare cost increases. The current budget request is 2.49% over the starting base budget. That concludes the brief budget overview. At this time, I'd like to thank you, committee members, for your time and open it up for any questions.
Lost my screen there. Thank you for the presentation. Are there any questions from our members? I do not see any. Ms. Baker-Olson, thank you for your presentation. Been useful, informative, and we'll take it into account as we continue building our budget this year. Thank you so much.
Thank you for your time, Chair and committee.
We'll now move into the bill presentation. The first bill we have up is Senate File 1034. Senator Duckworth.
Thank you, Mr. Chair and members. Appreciate your time this afternoon. If it's okay, Mr. Chair, I can proceed with the presentation of the bill.
All right, Senator Duckworth, please proceed.
Thank you, Mr. Chair. Before I get into the details of the bill, I wanted to make mention of an amendment that was drafted as it relates to this bill. I believe that staff is going to briefly describe the amendment, why it was created, and after that, after they've had the ability to do that, I'll go ahead and explain the bill in its entirety, if that's okay, Mr. Chair.
Senator Duckworth, did you want to offer the A1 amendment? I was informed you were not offering it.
That's correct, Mr. Chair. It's not being offered, but we still do want the opportunity to explain it, if you would allow that, Mr. Chair.
Do you want to do that now?
Sure, Mr. Chair.
All right. And did you want council, did I hear you right? Council is going to explain the amendment that we're not going to decide on?
Yes, please, Mr. Chair.
A little unusual. Council, is it Mr. Backus? Are you familiar with the A1 amendment that we're not going to make a decision on today?
Yes, Mr. Chair, I am familiar with it. Would you want me to describe it now then?
Yes, briefly.
Okay, it's in members' packets. It might be a tiny bit hard to understand it without fully understanding the bill, but the bill, it basically takes the requirements of the bill for the Bureau of Criminal Apprehension to investigate sexual conduct offenses involving National Guard members, and it moves it to a new statutory section, 299C.81. The reason for that is the current statutory placement in the bill places the responsibility within the Bureau of Criminal Apprehension's independent use of force unit. And the main significant thing about the placement in the current bill is that entire section is scheduled to sunset on August 1st, 2024. So by placing it within that section, this also will expire or sunset. So that's the main substantive thing that the amendment does. And I know that the Bureau of Criminal Apprehension, I believe, was somewhat concerned about moving this as the A1 amendment does for fiscal concerns. And I'm sure if you wanted to, you can ask them or Mr. Turner about that.
Why don't we hear what the bill does in its entirety from the author, and then we can move into that discussion a little later. Senator Duckworth.
Thank you, Mr. Chair. I appreciate it. We're on Senate File 1034. This is a bipartisan bill that's also been heard and laid over in the House. It assigns the Minnesota Bureau of Criminal Apprehension the additional duty of investigating criminal sexual conduct cases where one member of the Minnesota National Guard accuses another member of the Minnesota National Guard of criminal sexual conduct. Also, the BCA would assist a local agency at the agency's request if the incident occurred in a jurisdiction outside of the state. You'll hear from testifiers today why this bill is necessary and how it can help regarding investigations in the future. Several key stakeholders have been collaborated with in an effort to gain consensus regarding this bill. You'll hear from the Department of Veteran Affairs, the Minnesota National Guard, and survivors of sexual assault regarding their support of this legislation. Additionally, Superintendent Evans of the Minnesota BCA is also on hand to answer any questions that may arise in relation to their role regarding this bill.
You have a number of testifiers, Senator Duckworth. Perhaps were you done with your testimony?
And Mr. Chair.
All right. We'll hear from Donald Kerr, Executive Director of Minnesota Department of Military Affairs. Director Kerr.
Thank you, Mr. Chair.
Identify yourself for the record and then proceed.
Yes, sir. Thank you, Mr. Chair. For the record, my name is Don Kerr. I'm the Executive Director of the Minnesota Department of Military Affairs. We're the state agency that oversees the National Guard. And though the department typically remains neutral in legislation that's outside the direct scope of the military code, we strongly support this bill because it will close a critical gap that we have in our current ability to conduct timely, credible, and consistent investigations that can be used to enforce discipline in the National Guard in this area of great concern in this era. And sir, with that, I will stop talking and stand by for any questions regarding the agency. I know there are a lot of testifiers to get through.
We're going to hold questions until after all the testifiers. We'll move on to Mr. John Thompson, coordinator for the Minnesota National Guard regarding sexual assault response. Mr. Thompson.
Thank you, Mr. Chairman. My name is John Thompson, and I'm the Sexual Assault Response Coordinator for the Minnesota National Guard. I'd just like to say that this bill provides needed reinforcement to the foundational trust and faith that our airmen and soldiers have in both the Minnesota National Guard as an organization and our sexual assault prevention and response programs. Anything that we can do to shorten the investigative timelines associated with our sexual assault cases is going to have a positive impact on the victims and survivors whom we support. And thank you, Mr. Chairman.
Thank you, Ms. Thompson. Sarah Kostick will be representing the Minnesota National Guard. Ms. Kostick.
Good afternoon. Good afternoon, Mr. Chair.
Are you, Ms. Kostick, on your name under your window tile, it says Bonnie Daniels.
Yes, we're here together, two different
All right.
testifiers.
Okay, I see. Well, why don't we hear from Ms. Kostek first?
Yep, that's me.
All right.
Uh,
You're a
my name-
member of the National Guard?
Yes.
All right, please proceed.
My name is Sarah Kostek. I'm here to testify in support of SF 1034. In 2014, I was sexually assaulted by my first sergeant, the senior most enlisted member of the unit. Because of the National Guard policy, I had to report the assault to local law enforcement. The local law enforcement did not take my case serious at all. They asked if I was at a local bar, if I still would have reported it. They also assumed that Camp Ripley, military police, would take care of it on their side. From there, I became one of the first in Minnesota to experience a complex investigation. This is when a team of senior military members travel to Minnesota to investigate. Then they go back to Washington, D.C. to review the findings and make a decision. This was almost a 2-year process. I feel that if I reported my case to the BCA, they would have understood the military's limit and would have a trained victim investigator to handle the report with care and respect. The investigation did result in an honorable discharge of my first sergeant. Nothing was noted on his record, and he continued to serve as a police officer in his local hometown. And then, then I just say, please vote yes for this bill so these criminals can be taken off the civilian streets as well as the military ones. By having the BCA take our cases, it will result in a unified process, ensuring the investigation time so victims can begin the healing process. Thank you for your time, Mr. Chair.
Thank you, Ms. Kostek. What jurisdiction did you report your assault? What local jurisdiction did you report it to?
Morrison County.
Oh, okay. All right. Thank you. We'll now move on to Shayla Scholl, another member of the Minnesota National Guard. Ms. Scholl.
Thank you, Chair Limmer and committee members. My name is Specialist Shayla Scholl. I'd like to thank everybody for being here today, specifically Senator Duckworth and Senator Isaacson. Sorry about that. My name is Specialist Shayla Scholl. I'm here today to testify in support of Senate File 1034 because I am the reason why this legislation was introduced. I was sexually assaulted by another guardsman the night I got off the plane from graduation of advanced individual training in 2016. I was not expecting to be discouraged from reporting my sexual assault when approaching law enforcement. After that, I never had the motivation to act on it further. Until late 2017, I had just finished treatment for stage 4 blood cancer when I had received messages on Facebook from a civilian woman asking about what had been done to me. Turns out everything that was done to me was done to her too. I spent a little over half of my obligation to the Minnesota Army National Guard in a sexual assault investigation. That is 2.5 years. This is approximately the average reported time for cases to last, according to the state's last SAPR response board. The investigation resulted in an other than honorable discharge for my perpetrator. What you all don't see is the toll this has taken on my family, my friends, mostly myself and my children. I can't say that I still don't blame myself. The reason why I'm here today is not because I wanted justice for myself. I carried this by myself for a year before I reported, until I was approached by somebody else. But I will have to forever sit with the guilt of being the service member in a group of civilian women who look to me to be, to meet, to follow, to uphold, and exceed the standard of the law. And somebody who puts service before self. Reporting put a target on my back that I will have to live with forever, but that is the cross that I will bear if it prevents others from carrying the same. That is a hell of a weight to carry. This legislation would have given me access to an equal, uniform, and timely investigation from the civilian side that I deserved when I attempted to report the first time in 2016. I continue to serve beyond my obligation to the National Guard, now in the Army Reserve in Texas with my active duty spouse. But in Minnesota will always be my home, especially the Brainerd Lakes area and Mounds View between both of our families. With this legislation, it will ensure that soldiers and airmen of this organization in Minnesota are entitled to fair and unbiased sexual assault investigations by the BCA, so we can continue to serve in our communities safely. I urge you to vote yes on Senate File 1034. Thank you, Mr. Chairman and committee members.
Thank you, Ms. Scholl. And we'll now go back to Bonnie Daniels. Ms. Daniels,
Yes.
we can see you. Would you identify yourself for the record and then proceed with your account?
Yes, Mr. Chairman. My name is Bonnie Daniels, and I'm here today to testify in support of Senate File 1034. I was sexually assaulted by my Master Sergeant on January 9th of 2016. It was a drill weekend. Prior to the assault, I had always thought of myself as being extremely goal-oriented, outgoing, happy, and carefree. I had just graduated and was planning for the start of my career in the Houston, Texas Medical Center as an X-ray tech. The assault changed everything. My always positive attitude was non-existent. I blamed myself. I told myself things like, it's my fault I had a drink with him. I should have known better. Nobody actually cares about me. Nobody will believe me. I'm annoying people. I'm crazy. People will think I'm overreacting. I can't trust anybody. Men only want me for sex. I'm not good enough. I'm worthless. A nobody. Those feelings of guilt and shame haunted me throughout the entire investigation, as well as the sickness in my stomach, hearing I wasn't the only one. I had my first thoughts of suicide right before my 29th birthday, a little over a year and a half after I reported the sexual assault. Shortly after my first thoughts of suicide, I drove to the VA in Houston for an appointment with the military sexual trauma coordinator. She was surprised I hadn't canceled that appointment because it was the first day of Hurricane Harvey that hit Houston in August of 2017. I told her that I had called for help once before, a few months after I was sexually assaulted, because I knew that I needed help, but nobody ever called me back. It took me a year and a half to call again. If I had canceled that appointment, I didn't know how long it would be before I had the courage to call again, if I even made it that long. The entire investigation took 2 years to complete. Please vote yes to Senate File 1034. When it comes to somebody's life, every second counts. Vote yes to ensure them that a timely investigation, which would provide them with that piece of closure that is needed to truly begin to heal. 2 years is too long. Thank you, Mr. Chairman.
Thank you, Ms. Daniels. Ms. Daniels, if I could ask a quick question, where was the location of your assault?
Mr. Chair, I find it a little bit invasive, that question and the question of where they reported it to law enforcement. These are survivors, and I don't think they've made their statements of what they're comfortable to talk about.
Well, I guess I'll leave it up to the individual to answer. They don't have to answer. If it happened outside of the state of Minnesota, then it might reflect how pervasive this issue is across the country. Ms. Daniels, if you don't want to answer, you don't need to.
It was here in Minnesota. It was in Olivia, Minnesota.
All right, thank you. Senator Ingebrigtsen.
Mr. Chair, are you ready for questions? I'm sorry.
Yes,
Yeah,
yes,
okay.
I am. We're done with our testifiers.
I do have a couple of questions, and I'm Mr. Kerr, if I can. You mentioned the gap. Can you explain that a little bit further to me? And jurisdiction-wise, these are terrible incidents, by the way. I absolutely feel for the testifiers and have been around that myself over the years and investigated that. But jurisdiction-wise, I'm just wondering, have the sheriffs been involved in this decision-making process? And maybe somebody can ask me if they are members of the National Guard and it's off base. And I guess the last testifier said it was. Who would the BCA then do that, or would it be a local jurisdiction that would handle it?
Senator Ingebrigtsen, let's first go to Director Kerr. And then if anyone, I see that Ms. Scholl wants to participate in this discussion. Director Kerr.
Thank you, Mr. Chair. Thank you, Senator Ingebrigtsen. It's a good question. It's a complex issue. So jurisdictionally, the only crimes that the Minnesota National Guard has primary jurisdiction over are military-specific crimes, and these are not military-specific crimes. For all instances that is not a military-specific crime, the local jurisdiction are the ones that are responsible to do the investigation. Some of the challenges we have with that, though, inside the military, status matters, and we do not allow relationships between people of different grades, and that is not a big deal for a local county attorney. So there may be some evidence that would be important to us from a command climate perspective that wouldn't be important for a local prosecutor. And so often these things are not done with us in mind. Currently, when we do have a situation like this where we do not feel that a local jurisdiction has done what we need from a discipline perspective, we have the option to request an investigation from the Office of Complex Investigations at the National Guard Bureau. And that is how most of these are investigated. The challenge with that is that's one entity that's covering down on 54 states and territories. And so, as you can imagine, they have a pretty good backlog, and it takes a long time to get an investigation done through the Office of Complex Investigations. We think that this law would really be helpful because it would automatically turn the BCA on whenever there were an allegation of sexual misconduct between members of the National Guard. And it would give us a more consistent and more timely investigation that we could then take disciplinary action or administrative action. I hope that answered the question, Senator Ingebrigtsen. If not, I'll stand by.
Mr. Chair.
Senator Ingebrigtsen.
Yes, that does. That's sounds like a horrible situation when you're talking about having to go to the top with regards to the military. The time factor there, I think, with the victims would be short of devastating. So I'm still trying to get myself around this and grab this. I know Senator Limmer, and maybe, I don't know if this should be maybe directed to staff or whatever, but I know if there's a prison, and maybe we're talking a whole different thing here. If there's a prison assault going on in a state prison and it's within a certain county jurisdiction, I believe if it's a city or a county, the local jurisdictions would be handling that. Does the BCA handle those? I mean, this is certainly a different crime than what you're going to find, not totally, but in prison systems. I'm just wondering, does the BCA, maybe the BCA should weigh in on this if he's available.
Do we have Mr. Superintendent Evans, Drew Evans from the BCA? Could you weigh in on this question of Senator Ingebrigtsen?
Certainly, Mr. Chair and Senator Ingebrigtsen, for your question relating to the prisons across Minnesota, it does operate in much the way it would in any other jurisdiction if we were assisting them with an assault. We are contacted by the local jurisdiction that has jurisdiction over that area and will provide assistance if it's within the areas of that we provide assistance in. So we don't automatically investigate anything within the prison system.
Senator Ingebrigtsen.
Thank you, Mr. Chair. So Mr. Superintendent, I'm wondering how many cases are you envisioning happening here? And do you have any idea? I guess maybe that came from Mr. Kerr and the sexual assault response coordinator, Mr. Thompson. Do you have any idea as to how many there's going to be in the state of Minnesota?
Mr. Thompson, would you have a number for us?
Yes, Mr. Chairman and Senator Ingebrigtsen, we're looking at approximately 10 to 12 cases per year on average. We looked at the past 3 years. Out of 68 total reports, 45 took place in Minnesota, and 32 of those 45 cases involved a National Guard offender and a National Guard victim.
Okay. So is it, Mr. Chair?
Senator Ingebrigtsen.
So is it your feeling that this is the right way to go, and will the victims be quicker? Will they get response quicker, or is there going to be any paperwork or any stalling or anything? I guess that's not the right word, but you know what I'm talking about. If there's a complaint on the base, are they going to be immediately contacted with the BCA?
Ms. Thompson.
That is our hope, that this is going to reduce the timelines that we now see. Like you've heard from the other testifiers, our typical cases that go to investigation, we're looking at up like 2 years, sometimes a little bit more. And that's entirely too long for these cases to drag out.
It's way too long. Thank you. Thank you so much.
Senator Ingebrigtsen, you made mention of asking a victim. I see that Ms. Scholl put her hand up in response to that request. What was your question?
Well, I guess I don't know. I think it was answered here. I think we're talking about a time factor and there's and I understand the believability thing. I guess I don't like to hear that, but when there's any doubt like that, I know a victim really suffers with leads to more time and more suffering, and I hate to see that. So I don't know that I have a question for her. I think it's pretty clear to me that this is a very slow process the way it is being handled now, and this bill seems to certainly deal a lot more responsive to the victims.
Thank you. Ms. Scholl, I noticed that your hand went up immediately when Senator Ingebrigtsen posed that question to the group. And I was wondering if you could just briefly tell us what your response would be.
Absolutely, Mr. Chair. Senator Ingebrigtsen, the thing that I wanted to say specifically is that this legislation was around like before my case happened, it would have prevented most likely the ability to have to wait so long relying on Office of Complex Investigations to investigate my case. If I had the ability to have this investigation done by the BCA first, I would have never had to wait so long. So this essentially would prevent us having to depend on OCI to do the investigation that should be done already from the civilian side. That's all I have.
Ms. Scholl, how long did you have to wait?
So given the fact that I reported afterwards, I held on to it for about a year, and then I reported in 2017, and my investigation was concluded in August of 2019. So it was about exactly two years and some months and change.
Thank you, Ms. Scholl. This kind of reminds me of the series of accounts by the Star Tribune called Denied Justice. It reported of a continual pattern of behavior that law enforcement didn't seem to respond appropriately to in a timely way to rape victims in Minnesota over many years. Senator Kiffmeyer. Oh, Senator Ingebrigtsen first, Senator Brixen.
Just to that final point, and thank you to the victim. I guess to Mr. Thompson again, what's being done to prevent this? Now we're talking about to try and deter this crime from going on. Is there something in the military protocol or information that knows that it's just not going to stay in-house? There may be a thought process if you're in the military, this is going to go nowhere, because it is predominantly a male situation that goes on. I mean, is there something that you're going to be able to put out there and say, should this ever happen on the base, it's going to be handled outside the agency, and maybe that would be some kind of a deterrent? We talked about that, and then I'll end with my questions then, Mr. Chair.
Was that to Mr. Thompson? Or?
Yeah, Mr. Thompson, who is the Sexual Assault Response Coordinator.
Thank you, Mr. Chair and Senator Ingebrigtsen. All I could say is every bit of our effort is focused on the prevention side of the house these days. We have a very robust response capability to respond after the fact. Our focus over the past 1.5 to 2 years has shifted to preventing the assaults from happening in the first place. And anything that we can do to contribute to the program, that acts as like the incentive to not offend is something that we're interested in. And I think this is one piece of it. You know, we do what we can to educate our soldiers from day one as what our expectations are in regards to appropriate behaviors in our workplace. We hammer down on those Army values and what we consider acceptable and not acceptable behavior, both in and out of uniform, on and off duty. It applies evenly across the board. And this bill is another kind of tool in the organization's toolbox to get after offenders.
Thank you.
You're welcome, sir.
Sarah Kittmeyer.
Thank you, Mr. Chair. First of all, I just really want to say how grateful I am for, and they're survivors. They were a victim at one time, but they're survivors. And so to thank you, Ms. Kostick, Ms. Scholl, and Ms. Daniels for stepping up and stepping forward as you did in your service for the military in defense of our country, how much we appreciate that. And then in the midst of that, to have this attack, which can happen in the private sector or National Guard. I mean, the predators are there, and they take advantage of any kind of situation, no matter the efforts. But I really appreciate your survivorship coming forward and turning it to good. I think of Adam Walsh having his son horribly. I think of from Long Prairie, Minnesota. I'm just trying to think of the name of the family there, who Jacob Wetterling, to the Wetterlings and what they've all done, Mr. Chair. And it's just great when they do that and how valuable that is, and to be here today. And it's also very difficult for them, Mr. Chair, because it opens up some wounds and makes them have to think of those things and go through it again. And the one redeeming thing is they think of others and how they can help them, how they can help the National Guard in their desire to do well and to do better. And thank you to them for being here today, Mr. Thompson and Mr. Kerr, in supporting of this, and the author, Senator Duckworth, as well. This is not an easy kind of thing, but without the survivors, it makes it a little bit more difficult. They can tell the story that puts a face on what this is. But it is judiciary. They deal with a lot of dry, practical issues kind of things too. So we certainly understand that. But I just thought, Mr. Chair, that I just really wanted to communicate to them. And thank you for letting me have the time.
Thank you. Senator Pappas, you had your hand up. Did you want to make further
I did,
comment?
Mr. Chair, but Senator Kiffmeyer said what I wanted to say, and thank these three brave women of coming forward. And it's very timely in that Congress is currently debating the Violence Against Women Act. It's definitely a pervasive issue. Thank you.
Yeah, I believe we have universal theme here by all our members. Senator Anderson.
Thank you, Mr. Chair. I do have a question of why the A1 amendment was discussed early on, and was there a purpose, or was there something?
Senator Duckworth.
Thank you, Mr. Chair. Thank you, Senator Anderson. I'm happy to touch on that. The reason the amendment was drafted and why I wanted to speak to it at the beginning was just to highlight, for the good of the committee, the sunset provision that does exist that was uncovered by staff during their research regarding this legislation. I wanted the committee to be aware of that in the context of this bill, and just also to offer the chair, as he's seeking to decide what he ultimately wants to do, perhaps in relation to this bill, that there is another part of law that this could fall under. But just really to highlight the sunset provision that would be involved as it relates to this legislation, Senator Anderson. Hopefully that helps. Happy to answer any additional questions you might have.
Thank you, Mr. Chair.
Thank you, members. Senator Pappas.
Mr. Chairman, it just raised more questions because I didn't really get a chance to see the amendment. I'm not sure where it is. So does the current bill have a sunset provision and the amendment removes it, or vice versa?
Senator Duckworth.
Thank you, Senator, or thank you, Mr. Chair and Senator Pappas. So where the current bill would be placed into law, there is a sunset provision that's tied to the BCA unit that would be tasked with this additional duty, and that sunsets in 2024. The amendment would move this bill into a different portion of the law in which no sunset provision would exist as it relates to this specific instance. However, in consultation with the BCA and getting their feedback, they're more comfortable keeping it where it is currently and hopefully addressing that sunset provision at a future date with legislation. It has to do with their ability to task the individuals they would like to conduct the investigation and the unit they would like to conduct the investigation appropriately. So Senator Pappas, this seeks to accommodate that. However, it does leave the door open for further conversation and feedback to continue to improve this legislation, which I know myself and all stakeholders are open to. Thank you for that question.
Senator Pappas? Okay. Hearing no further. Oh, Chris Turner. Mr. Turner, would you give a review of potential cost and fiscal impact? You'll have to unmute, Mr. Turner.
I'm sorry. Chris Turner, fiscal analyst. The BCA states in the fiscal note that the estimated workload, about 10 to 12 cases a year, would require one full-time special agent, which with equipment, supplies, and training comes to $160,000 annually. And if I might add about the amendment, there was concern with the amendment that it would drive up the cost of the bill because it would take the investigations outside of the independent use of force unit. And the investigations would not be able to use the support infrastructure, and that would drive up the cost of the investigations. That's one of the reasons that that the amendment has been withdrawn.
All right. Thank you, Mr. Hearing no further discussion, we will be laying the bill over for possible inclusion in our omnibus bill. We'll now move on to Senate File 432, Senator Ingebrigtsen.
Thank you, Mr. Chair and members. Senate File 432 is the suspension or failure to appear for traffic violations, driver's license suspension reform bill. I'm just going to highlight a couple of things that the bill does, and then I do have some testifiers here that are very, very active in this particular bill. And Mr. Chair, you're very well aware of where this whole situation has been over the years and where we are now, and what we try to do, I guess, when we do legislation is try and make it work a little bit better. First of all, it stops the driver's license suspensions when the only violation is failure to pay a traffic ticket. There's a lot of them, and they'll tell you exactly how many, not exactly, but they'll tell you approximately how many. It also eliminates the additional suspension period after paying a ticket for driving after suspension, so people who pay their fines can get back to work. I think that's important. We're not talking hardened criminals here. We're talking about folks who make a mistake and they just time slips by and all of a sudden they're driving under suspension and it just keeps adding up and they can't seem to dig themselves out. This also maintains the collections process for unpaid tickets, so people will still be held financially accountable. I think that's important. It does not impact the suspensions for DUI, reckless driving, habitual offenders, etc. So the bad actors are still going to be addressed when it comes to traffic. This is the ones that are making these minor mistakes out there that get strapped down financially, and there's no way of being able to account for this. So with that, if I could, Mr. Chair, I'd like to turn it over to a testifier, Anna Odegaard, the Director of Minnesota Asset Building Coalition, and then you have a list of other testifiers should you need.
Yes, thank you, Senator Ingebrigtsen. Before we begin with testifiers, I had authored last night an A6 amendment, and just for notice for our testimony today, I have withdrawn the A6 amendment. We will not be hearing it. So, Ms. Odegaard. welcome to the committee, and would you identify yourself and then proceed?
Thank you. Thank you. Yes, Chair Limmer and members of the committee, thank you for the opportunity to testify in support of this bill. My name is Anna Odegaard, and I'm the director of the Minnesota Asset Building Coalition. That's a coalition of nonprofit organizations across the state. We have about 135 members, and we're all really focused on working directly with low-income Minnesotans and supporting opportunities for those families to become financially stable. I want to just quickly thank so much Senator Ingebrigtsen for championing this bill, and also thank Senator Latz, one of the bill's co-authors who sits on this committee, and of course, thanks Chair Limmer for hearing the bill today. A basic traffic ticket for speeding or a broken taillight costs about $150, and you're required to pay the ticket in full or request a court hearing within 30 days. Currently, if you fail to pay or appear on that ticket, the violation gets certified as a conviction on your driving record, and the unpaid fine is sent to collections. As an additional penalty, the state suspends your driver's license. This bill, as Senator Ingebrigtsen pointed out, maintains the collections process, but it does, and your violation would still be certified to your record, but it would eliminate that driver's license suspension, which allows people to continue driving legally to work and to take care of their family while they pay off their court debt. As Senator Ingebrigtsen pointed out, it also eliminates that additional suspension after a payment for driving after suspension, so people can get back to work if they don't have any other holds on their license. Let's see, Senator Ingebrigtsen said a number of the points I wanted to make. He obviously has been a great champion for this bill. I do just want to mention the habitual violators law would still be in force. It requires a license to be suspended if someone gets more than 3 moving violations in 12 months. So our position is that license suspensions should be used for dangerous driving or habitual violators. But when somebody's struggling to pay that traffic ticket, it doesn't benefit anyone to make it illegal for them to drive to work. The Department of Public Safety estimates that if this bill passes, it would reduce driver's license suspensions each year by about 112,000 suspensions across the state of Minnesota, or about a 60% decrease in license suspensions. As you may know, there's been a broad coalition working on and supporting this bill over the last 3 years. I'd just briefly like to call your attention to letters of support provided by the Minnesota County Attorneys Association and the Minnesota State Bar Association, both of whom have endorsed this bill, as well as letters of support from Justice Action Network and the Minnesota Catholic Conference, ACLU Minnesota, and many community organizations. I'd also like to bring your attention to a resolution by the American Legislative Exchange Council, also known as ALEC, supporting limiting driver's license suspensions to violations that involve dangerous driving. I appreciate all of these partners who have helped move this reform forward, and I hope you'll support this bill. Thank you.
Thank you, Ms. Odegaard. We'll now hear from Mary Ellen Heng, Deputy Attorney. Deputy Attorney Heng.
Thank you, Chair Limmer, members of the committee. My name is Mary Ellen Heng. I am the criminal deputy in the Minneapolis City Attorney's Office. My office prosecutes all of the misdemeanor and gross misdemeanor offenses that occur in Minneapolis, and that would include these offenses that we're talking about: driving after suspension, driving after revocation, driving after cancellation. I am here to testify in support of this bill as a misdemeanor prosecutor. I have spent almost 24 years prosecuting misdemeanors, and I am fully in support of this bill for 3 reasons. First, prosecuting these offenses, driving after suspension, where the suspension is based solely on the inability to pay fines, is simply not a good use of anyone's resources, not my resources, not the public defender's resources, not the court's resources. Prior to the pandemic, my office averaged in court about 500 driving after suspension cases each year. That's not even all of the cases that come through the court system. These are payable offenses, so many, many more are heard by the hearing officers in the Violations Bureau here in Hennepin County. But my office spends time on approximately 500 cases each year. With the pandemic that occurred a year ago, the court system virtually shut down, and we are now facing a massive backlog of cases as the courts slowly reopen. And for me, when the courts are back in session and we are able to return to in-person court hearings and trials, I would rather see my office spend its resources prosecuting domestic assaults, DWIs, reckless driving, not someone who's suspended simply because they cannot afford to pay their ticket. The second reason that I support this bill is I do not believe suspending an individual's license for an inability to pay does anything to promote public safety. Not only do they end up driving continuously because they need to on a suspended license, they often then drop their insurance or are unable to get insured. So now we have unlicensed, uninsured drivers on our street. And should they get into a traffic accident, whether through some driving conduct of their own, or sometimes accidents just happen, now we have an uninsured driver, and perhaps my victim only has liability insurance and not collision, and I may now have a victim who has no means to get restitution for the damage to their car. I want, as a prosecutor, licensed and insured drivers on the road. That is what makes safety on the roadways. The third reason that I support this bill is it does not in any way decrease the accountability of the individual. When an individual is given a moving violation, and as a result of their inability to pay that, they get the subsequent suspension. They still have to deal with that underlying moving violation, whether it be a speeding ticket, running a red light. That conviction will still be reported to their driving record. It will go towards, if they are a repeat offender, they will eventually be revoked due to the habitual violator. It does not do anything for revocations brought on by DWIs, things like that. All it is saying is that we don't want to further punish someone because they can't pay the fine by giving them increased consequences, but the underlying offense that brought that initial ticket, they are still going to have some accountability for because it will still be certified over to their driving record. So for those three reasons, I'm fully in support of this bill. I know our partners at the St. Paul City Attorney's Office are as well. And I appreciate you giving us the time to speak to you about it. And I hope that you will also support this.
Thank you, Ms. Hang. We'll now move to Jeanette Borner, Hennepin County Assistant Defender. Ms. Borner.
Good afternoon. Thank you, Chair Limmer and committee members. My name is Jeanette Berner, and I am currently the Director of Adult Representation Services in Hennepin County, where we provide court-appointed representation on civil matters, such as parent representation on child protection cases. I have represented clients experiencing poverty for the last 29 years. Previously, I was the Deputy Public Defender in Hennepin County. In both roles, I have observed firsthand how our current system of license suspension is not only excessively punitive, but also very disenfranchising. Payment of driver's license suspension fees often falls behind the many other financial obligations, such as restitution, probation fees, and other expenses in the justice system, not to mention personal obligations like getting food on the table. Courts implore defense attorneys to help clients get valid so they can meet conditions and gain stability with employment. Prosecutors, as Ms. Hang indicated, work diligently to make offers on traffic cases with a lens towards getting people valid. Social workers, community advocates, and probation officers plead for a way to help clients get valid so they can avail themselves to much needed resources and meet court orders. Defense attorneys urge clients to take personal responsibility for their needs because we know it leads to successful rehabilitation. They achieve sobriety, they seek necessary counseling, they remain law-abiding, and they pay their restitution. And at the end of the day, they often still can't get their license. The pandemic has highlighted some of these challenges. When before there were other options for transportation options, I should say, for visitation and child protection cases, treatment, therapy, parenting groups, and employment, it all disappeared virtually overnight. There was often no way for people to get from point A to point B. And whether we like it or not, driving is essential for economic and social stability. And in rural areas where the only transportation option is a car, a suspended license makes obtaining employment an even greater challenge. There has been a demand for employees that cannot be met, in part because of one's inability to drive to the work site. I want to close by sharing with you a project that Ms. Hang and I worked on a few years ago. A Hennepin County community corrections manager called us regarding their highly successful program that's designed to reintegrate probationers back into the workforce. This program connects participants to work sites, providing them support and transportation to get their foot in the door with local employers with an eye towards being hired permanently at a livable wage. We were contacted by the division manager because the common barrier these participants faced was not having a valid license. Knowing that this would be required once they were hired, they asked for assistance. Ms. Hang and I set up what we'd like to call a pop-up driver's license team at the site, and we tried to help navigate the issues. We learned that outstanding traffic debt was the primary reason for their suspension. Often one unpaid ticket started their cycle. They needed a license to obtain employment, but needed employment to get a license. While we did not achieve 100% success because we didn't have a pot of gold, we were successful in helping a few become valid, which opened the door for them for permanent employment. I really appreciate your time and commitment to this important change that reflects the needs of our communities throughout the state, and I'm happy to stand for questions at the end. Thank you.
Thank you, Ms. Borner. We'll move on to Leah Jackson. Ms. Jackson, are you on board with us?
Mr. Chair.
Yes.
Hello, Mr. Chair, members of the committee. My name is Leah Jackson. I grew up in Otsego, Minnesota, and now live in Minneapolis. I currently work as an international account manager at a local logistics company. Thank you for the chance for me to tell you about how the driving suspensions have caused a significant impact on me, both financially and occupationally. In October of 2014, I was taking a left turn at a green light yield, and I pulled out into the intersection like I was taught in driving school. And as the light turned yellow, the last car sped up, causing me to have to wait longer, and I was not able to complete my turn until the light was turning red. I was pulled over immediately and told that waiting in the intersection after a light is red is illegal. I was given a ticket for obstructing traffic and intersection gridlock, which cost $135. I was 20 years old at the time, and I had just gotten a new job as a store manager and had moved into my own apartment for the first time. In fact, I was driving back to my hotel from my job training when I got the ticket. I hadn't got my first paycheck yet, and I had to save up for rent, so I didn't have the money to pay for the ticket right away. I actually wasn't sure how long I had to pay the ticket, and I thought I would get to it after I'd gotten a few paychecks and knew I could cover the basics. The following February, I was pulled over, told my license was suspended, and I was given a driving after suspension ticket that cost about $300, including all the fees and surcharges. I had just moved, which may be why I hadn't gotten the notice about the suspension, and I had no idea I was suspended until I got pulled over and got that ticket. So by now I had about 500 in fines. I knew I wouldn't be able to pay it until I got my tax refund. But part of my responsibility at my job at the time as a retail store manager was to make daily bank runs. So I kept driving to keep my job. Within about 2 weeks, I got 2 more driving after suspension tickets, one while I was making a bank run for work and one while I was driving to my second job as a dance instructor. After that, I started asking friends to come and pick me up during my shift to drive me to the bank so I wouldn't get any more tickets. This was also before Ubers and Lyfts were so readily available. On days when I wasn't able to get a ride, I really wasn't able to fulfill my duties as a store manager. And I was so stressed because not only was I in trouble at work, but I couldn't ever visit my family who lived 45 minutes away. And I still couldn't save enough money to pay off the debt. When my tax refund came, I went into the court and talked to a hearing officer who was able to reduce my fines from $900 to $600. I paid it off and was able to get my license back, but my problems were far from over. Because of the driving after suspension tickets, my auto insurance company dropped me as a client, and I wasn't able to find new insurance for less than $1,000 a month. If they would even accept me at all. Finally, I got connected to a broker through a customer, and I was able to get insurance for $650 a month. My insurance costs since then have gone down a little bit every 6 months, and after 5 long years, I am finally paying a normal rate. If you add up the total cost of these tickets, plus the increase in auto insurance for those rough 5 years, it adds up to over $16,000. If my license had not been suspended, I would have been able to continue driving for work, keep my insurance at an affordable rate, paid the original ticket out of my tax refund. That would have allowed me to use the rest of my tax refund and work savings for something much more meaningful and fulfilling. Maybe would have been able to buy a house by now. I know it's important for people to drive safe, but it doesn't seem right for one traffic ticket to add up to over $16,000 in costs. So I hope the legislature will figure out a way to stop suspending driver's licenses for people who might not be able to pay the whole cost of a ticket right away. Because especially now more than ever, passing this bill will make a difference for so many Minnesotans.
Thank you, Ms. Jackson. We'll now move into our final testifier, Mr. Jason Flores.
Mr. Chair, thank you.
Welcome to the committee. Would you identify yourself for the record?
Thank you, Mr. Chair, members of the committee. My name is Jason Flores. I'm the State Director for Americans for Prosperity here in Minnesota. Thank you for the opportunity to be here today and testify in support of this very important reform that's in Senate File 432. We do urge you to support this bill. Just a couple of quick points I want to reiterate, some of which have already been made. First, the suspension of a driver's license for unpaid debts often triggers a cascading set of unintended difficulties for an individual and their family, as we just heard about. It is an especially difficult and disproportionate burden placed by government on disadvantaged lower income communities and actually makes it harder to get those original debts paid. Second, we believe that law enforcement resources should go toward ensuring public safety, not toward debt collection. Studies have documented personnel time needed to process each traffic stop related to suspended licenses, and it adds up to more than $10 million in costs to Minnesota taxpayers. That's time spent detaining, questioning, and processing individuals who pose no threat to public safety. Third, while this reform aims to prevent some of those collateral consequences from spiraling, it doesn't let offenders off the hook. Minnesota has alternatives already in place to ensure that people are still held accountable for paying their debts. That includes ongoing collections proceedings, ultimately garnishments, liens, revenue recapture. This bill only deals with unpaid debts, so it does not change any suspensions of licenses under Minnesota's habitual violator law or for dangerous and negligent driving, including mandatory suspensions for DUI. It's just the unpaid debts that this addresses. Dangerous and unsafe drivers will still be and should still be held to account, but suspensions will actually be tied to that driving behavior and threats to public safety and not to somebody's ability to pay. Mr. Chair, thank you so much for your time today. Thank you for hearing this bill. Be happy to stick around and answer any questions.
Thank you, Mr. Flores. We'll open it up for discussion at this time. It doesn't look like there's much to discuss right now.
Mr. Chairman?
Oh, Senator Bingham, Senator Letts, I think Senator Bingham was ahead of you by a mere fraction of a second. Senator Bingham.
Thank you, Mr. Chair. I know you probably didn't have it on gallery view, but I just, not a question, just want to say thank you, Senator Ingebrigtsen. This is a long time coming, man. It shouldn't have taken this long to get this bill through. Look, it's expensive to be poor. And when you know, as the testifier said, you know, you have such a minor infraction and then you can't pay, the license goes away, you can't get to work, then it's just a vicious cycle. And so I just applaud the efforts. Hope we can get this across the finish line this year. It's a long time coming.
Thank you, Senator Bingham. By the way, I was on gallery view, but there's so many people watching it. I was on another page of gallery view. Senator Latz.
Mr. Chairman, just to emphasize the point, it happens that this morning in my law office, I got a call from a former client who had moved to Indiana. And the reason she was calling me is because she's got a bunch of unpaid traffic tickets from Minnesota. She wasn't quite able to figure out how to get it all taken care of from there. She ended up with a warrant out for her arrest. And the long and short of it is she's paying attorney's fees to try to sort everything out for her here, in addition to paying all the accumulated traffic debt. It just doesn't make any sense what she has to go through. And I've had this client after client, calls me or they come into me with these kind of problems. They just escalate. And my last point is when I first joined the Senate, I first joined the Judiciary Committee. You may recall this, Mr. Chairman. We had testimony from an assistant Washington County public defender who testified that something like 60 or 75% of his caseload was driving after withdrawal cases. That'd be suspensions, revocations, cancellations, and so on. But that's enormous. And when you got 112,000 Minnesotans every year who would be affected by this, it tells you, just how much of an impact this law is having on people and how much of an impact this bill will have on people as well. So I encourage its support. Thank you.
Thank you. Senator Kiffmeyer.
Thank you, Mr. Chair. Question I have here is, can a person who has received a ticket like this, and like Ms. Jackson said, you know, just the consequences of all that and that circumstance is certainly sensitive to that and what that is like. Do counties, any of these jurisdictions, do they offer payment plans? If you go in and say, yeah, I get it, I want to pay my thing, but can I pay $10 a month till it's paid off? Is that ever an option? Just curious.
Let's see, who would want to answer that? Perhaps Ms. Odegaard?
I can not necessarily answer the question, but I do have like my personal experience.
Ms. Jackson.
Mr. Chair, thank you. So when I was going through figuring out how to pay for my tickets, because, you know, the Minneapolis and like the surrounding city areas, like the jurisdictions are kind of all over the place. So with the 3 tickets that I had, I would have had to go to actual court 3 times to be able to work out any payment plan or to diminish it at all. And it's just not really, just wasn't a viable option with having 2 jobs and, you know, at the time, no method of transportation. So that's just kind of my experience to be able to get that opportunity. It was really, really difficult and almost impossible.
Thank you. Ms. Odegaard?
Mr. Chair, thank you. And Senator Kiffmeyer. Yes, there are payment plan options, and my understanding is that different judges have different flexibility. But the problem is that under the current law, while someone is working on paying off those tickets through a payment plan, they still can't get their license back. And so it really puts people in this kind of catch-22 of they're trying to make their payment plan, but it's not legal for them to drive to work or to take care of their family. And then additionally, once those payments are made and there's a conviction on driving after suspension, people end up facing the problem that Leah did, where often their insurance will drop them or will become so expensive that they can't afford it any longer. So I do think that payment plans might work for some people, but once your license is suspended, it's hard to make the payment when you can't get to work.
Thank you, Mr. Chair. Thank you, Mr. Chair. Ms. Odegaard and Ms. Jackson, that clears it up. And I understand with this bill, it doesn't absolve them from paying their fines or doing any of that. They're just not going to have their license suspended. So they will still have to complete the payment. And I'm supportive of that. Thank you.
Ms. Odegaard, is it a one-time payment then that's required by the individual?
Mr. Chair, I'm sorry, do you mean?
When the payment is paid, ultimately, is it in the form of one single payment?
Oh, Mr. Chair. So my understanding is that many courts and, you know, if somebody's in front of a judge can offer a payment plan often, or someone can go to the court website and set up a payment plan. So often people can pay their tickets in multiple installments. But currently, you can't get your license back valid until you've completed all of those payments. So you're trying to make the payments without being able to drive legally. And that's how people get caught in that catch-22.
Yeah. And I would imagine that if one did make payments like that in the past, they could always rely on the U.S. mail to send that payment in, wouldn't they? There's been the statement that says, how can I make the payment when my driver license is suspended? There's other means to do it.
Oh, Mr. Chair, I think maybe that means how can I earn the money to pay off the debt if my license is suspended and I can't get to work? You're right. You can pay off those fines by mail or even online now.
All right. Thank you. Senator Pappas.
Yeah, Mr. Chairman, I'm just wondering if this bill is retroactive or any way for people currently with their license suspended to be able to get them back.
Why don't we ask counsel that, Mr. Backus, is there a retroactivity element to this bill?
Mr. Chair and members, to my knowledge, no, there's no effective date. There's no retroactivity. Perhaps one of the witnesses could comment on this. I it's possible that an earlier version of the bill had some kind of retroactivity element, and maybe they can comment on that.
Senator Ingebrigtsen, did you want to make comment about retroactivity?
Yes, Mr. Chair and Senator Pappas, there was a portion of the bill that was retroactive. However, the chairman of the Transportation Committee, where this made its first stop, said he would not hear it. He had never been in favor of that particular portion. So that had to be taken out, and the interested parties thought that was just fine. They took it out, and that's where it was at. So there is no retroactivity.
And I may want to remind us that we have a very narrow jurisdiction on this bill. And it's mostly the fine transference that's mentioned in the bill. Senator Ingebrigtsen, did you have anything else to add?
Nothing other than I see you have one more bill, and that's Senator Johnson. Of course, he can get the bills done in less than 30 seconds generally. So I'll just end with a couple of comments. This has certainly been a lot of work here, and I know a lot of people don't believe that folks are having to pay for their sanctions. One testifier said this poses no threat. Let's not forget why and how they got there. Obviously, there was a violation to get there. And here comes the heavy-handedness, Senator Latz. Sheriffs, generally are a little tougher than this, but this seems to me to be a real reasonable way to eliminate this, hopefully not taking away their jobs or their inability to pay for not only fines, but also life in general. So I think it's a good thing.
A heavy hand and a long arm of the law.
Thank you.
See what you did, Senator Ingebrigtsen? You woke up Senator Latz. Not waking up, I misspoke.
Yeah.
Senator Ingebrigtsen, I think our committee is done with its deliberations. Would you do the honors of moving the bill?
I would move, Mr. Chair, that Senate File 432 to be agreed to and to be sent to, you'll have to help me with that, Mr. Chair. Is it going
That'll
to
be the Transportation. We're waiting for our blessing. Senator Ingebrigtsen moved Senate File 432 be recommended to pass and re-referred to Transportation Committee. Hearing no further comment, all those in favor signify by saying aye.
Aye.
Opposed? The motion prevails. Thank you, Senator Ingebrigtsen.
Thank you, Mr. Chair.
Move quickly to Senator Johnson's Senate File 443.
Thank you, Mr. Chairman. And Senator Ingebrigtsen, thank you for leaving me 1 minute to present the bill today.
That's more than enough.
Appreciate the consideration.
It was that last minute comment by Senator Latz that got us to
That's
this.
right. That's what it was. Heavy-handed.
You feel better? Go ahead. I got broad shoulders.
Well, we shouldn't be too much over the time allotted. This is a very straightforward bill. Senate File 443 was brought to me by the Minnesota Home Care Association. It will provide a tool for putting some guardrails on individuals who are helping in the hospice services of Minnesotans across the state. What this does is it requires a registered predatory offender to notify the service provider, the hospice care provider, that they're dealing with a registered predatory offender. This is very similar to what's currently law in nursing homes and assisted living facilities across the state. For more on this particular bill, I do have a testifier. I'll cut short there. And if Mr. Chair, you'd like, we could go to Ms. Messerly to explain a little bit more in detail of where this bill is useful.
Yes, Ms. Messerly, would you identify yourself for the record and then proceed with your testimony?
Chair Limmer and members of the committee, I will keep this very short since we are over our 30 seconds, I believe. My name is Kathy Messerly, and I'm the Executive Director of the Minnesota Home Care Association. I'd like to thank Senator Johnson for bringing the bill forward. As I said, I'll keep this very short and would be happy to address questions if you have them. But we brought this bill forward, as Senator Johnson mentioned, because this is already the situation that facilities and home-based service providers are notified if they're going to be serving a predatory offender, and that includes home care. We are asking simply to add hospice into that language. Hospice care providers face risks every time they enter a home alone, not knowing who or what they'll encounter. And this is one small step in helping to ensure their safety. We ask for your support of this bill. And again, I'm happy to take questions, and thank you for your time.
Thank you. Senator Johnson, quickly, is there a penalty in the event that a person fails to register that information with a healthcare facility, home care service, or in this case, a hospice service? Or maybe I should ask the council that.
Council would be great.
Mr. Backus?
Mr. Chair, yes, there is a penalty for a violation of the predatory offender registration law, and I assume that this would be included. I might have to just verify, depending on how it's worded, but I assume that general penalty would apply.
I'm not really sure if that really will have a real effect when you have a person going into a hospice care facility. But are there any other discussion with Senator Johnson's bill? Hearing none, Senator Johnson moves that Senate File 443 be recommended to pass and move to general orders. Any further discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Aye. Opposed?
Aye.
Opposed? The motion prevails. Thank you, Senator Johnson.
Mr. Chair,
Senator,
I have
yes,
a quick
Senator
question.
Bingham.
Yep. So I'm getting a lot of emails and I'm seeing a lot of social media posts on catalytic converter thefts. I'm sure each of the members here are receiving the same. And while I know that it's probably a blend of commerce and judiciary, I was wondering if there's any intent to deal with legislation this year to combat this huge issue that's going on in each of our communities.
Senator Bingham, I believe that bill is in the Commerce Committee and we're awaiting it.
Okay, thank you, Mr. Chair.
Senator Latz, you wanted to make comment?
Yeah, thank you, Mr. Chairman. I know we've heard a number of budget proposals now, and the Senate Majority's budget proposal itself came out. I wonder if you can give us some idea based upon the slice of the pie that was allotted to the Judiciary Committee, whether you anticipate being able to meet the expectations, perhaps, or the goals of the bills and agencies that have come through here, seeking to fund their operations and the good changes in policy that have been passed.
Yeah, thank you, Senator Latz. I always have that same discussion in my mind upon the first budget target that I've been given in recent years. I believe it was $90 million that we were given a target. Keep in mind that 20 million of that is an immediate outgo for DACA expenses on the FAST bill. And so that brings us down to an adjusted gross of 70 million. And I always have this discussion with the chair of the Finance Committee, and I always keep pushing the pedal down for a little bit more because it seems like we always have a relatively low figure. And I don't believe this is any different this year. It seems that through negotiations, though, toward the end, we seem to get quite a bit more. Last budget proposal, I believe we received almost $100 million more that was added on to our beginning Senate target. And that became kind of the compromise dollar amount that had been worked out over time. I suspect it may not be a whole lot different, but I just don't, I haven't been made privy to anything beyond that 90 million. And right now it would be focused on our core function for DOC, DPS, and the courts. So it's a work in progress, Senator Latz.
So, Mr. Chair, as you know, there have been some extraordinary public safety needs in Minnesota. There are investigative needs. There are some proposals to strengthen our government services in a variety of ways in prevention as well as enforcement. And we have ongoing salary needs like the one we heard today from Civil Legal Services. So, you know, the whatever the budget situation is, the needs to provide the services that the public is still expecting to be provided, certainly within our area of the budget, continues. And so I encourage you to keep fighting, not only for the courts, which I know you have is a particular area that you have fought hard for over the years, but also for all the other elements of the budget that come through your jurisdiction.
Yeah, well, thank you, Senator Latz. We'll do our best, hopefully do it together. Well, thank you for it. It's about all I can say at this moment in time, but we'll keep the ball rolling and keep the pedal down. Having said that, there's no further business before the committee, and we stand adjourned. Thank you.